Dear students, welcome back to class once again. Today we'll be covering the remaining writ jurisdictions and drafting of writs. We have already seen that there are 5 categories of writs to be filed either before the High Courts or before the Supreme Court. And we have already covered the writ of habeas corpus, mandamus, and now today we'll be covering the writ of prohibition, quo warranto, and certiorari. Here is the list of references before you. You can read any of the following books. One written by Mr. R.N. Chaturvedi. Next one is by G.C. Monga. Third one is by C.R. Datta. Next is by K.K. Shrivastava. And last one is by S.R. Maineni. All these books are very good so far as the drafting part is concerned. Now, starting with writ of prohibition, as you know, as the name indicates, the writ of prohibition prohibits the court or any other authority to which it is issued to refrain from doing something which the court is about to do. In other words, it prevents the court or any other authority from assuming or threatening to assume jurisdiction which the court does not possess. And dear students, this writ is issued by a superior court to inferior court for the purpose of preventing inferior courts from usurping a jurisdiction with which it was not legally vested. In other words, to compel inferior courts to keep themselves within the limits of their jurisdiction. This writ of prohibition lies only against judicial and quasi-judicial bodies. It does not lie against a public authority which has acted purely in an executive or administrative capacity. And this writ does not lie against the legislative bodies also. Here is an example before you, a very important leading case, rural litigation and entitlement Kendra versus state of UP. In this case, mining in limestone quarries in Dehradun Valley was causing a lot of imbalances in environment. So limestone quarries was stopped by the Supreme Court under the writ of prohibition. You see, there is a distinction between writ of prohibition and certiorari. When a case is pending before the court, it can apply both prohibition and certiorari. Prohibition to prevent the court to proceed further with the case, and certiorari for quashing what has already been decided by the court. Thus, the object of prohibition is the prevention rather than cure, while certiorari is used as a cure. Now, we'll start learning how to draft a writ of prohibition. First of all, you will have to decide the name of the court. If you are filing this writ petition under Article 226, then it has to be laid before High Court of the relevant state. And if you are exercising your discretion of filing the writ petition in Supreme Court under Article 32 of Constitution of India, then you will write down the name of the Supreme Court at the top of your writ. So here is an example before you where the writ is being filed before High Court of Judicature at Allahabad, Uttar Pradesh. So the first line of your writ will be in the Honorable High Court of Judicature at Allahabad, Uttar Pradesh. In the bracket you will write down original civil jurisdiction. Then you will write down writ petition number dash dash of 2020. You cannot write writ petition number in advance because the writ is yet to be filed and your petition is yet to be serially numbered. Now, first of all, you will write down the name, parentage, and address of the petitioner. In our case, the petitioner is A, son of B, resident of flat number 906, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar. So, A is the petitioner. And so far as respondents are concerned, the first respondent is State of UP. Second respondent is Inspector General of Police, again UP. And third respondent is Inspector of Police, Noida, District Gautam Buddha Nagar of UP. Now, the center heading will be petition under Article 226 of the Constitution for the issue of a writ of prohibition. Now, you will address to the court to the Honorable Chief Justice and his companion judges of the Honorable High Court. The above named petitioner begs to submit as under. What is your prayer now? You will write down first of all the facts and lastly the prayer. So the facts of the case are like this, that petitioner A was appointed as a sub-inspector of police in the state of UP on 1st January 2020. And the petitioner served in the state of UP in various capacities in the district Meerut and Noida. These are the two places of posting where the petitioner has served. Now, the petitioner says that when he was posted at Noida and he was serving as sub-inspector, he was served with a charge sheet dated 2nd February 2020, and a copy of the charge sheet the petitioner has filed along with this petition. Now, the case of the petitioner is that after serving the charge sheet, an inquiry into the said charges was made by respondent number 3 from 15th February 2020, who submitted a report of inquiry dated 28th Feb 2020 to respondent number 2, finding the charges mentioned in the charge sheet above mentioned to be proved. So, the case of petitioner is that he was served with a charge sheet dated 2nd Feb 2020. The inquiry was started from 15th Feb 2020, and the inquiry officer submitted his report dated 28th Feb 2020 to respondent number 2. And the conclusion of the inquiry was that the charges mentioned in the charge sheet against the petitioner were duly proved. Now, the main challenge of the petitioner is that according to rules framed under UP Police Act regulating the procedure of disciplinary proceedings, the charges mentioned above could not be inquired into except by an officer of the rank of Superintendent of Police of that division, or with the approval of respondent number 2, that is Inspector General of Police of the division in the state of UP. Now the petitioner says that on 3rd March 2020, petitioner received a notice from respondent number 2 to show cause why he should not be dismissed from service. Now the petitioner is challenging the show cause notice which was issued to him for showing cause as to why he should not be dismissed from services. Now the main challenge of the petitioner is that the said inquiry was illegal and ultra vires because the respondent number 2 had no jurisdiction to take into consideration the said inquiry or pass any order on the basis thereof. And the inquiry instituted against the petitioner was held by a person who was not duly authorized to do so. He was not competent to inquire into the charges leveled against the petitioner in accordance with the rules framed under Police Act. Now, the petitioner wants to say in para 8 that the holding of a departmental inquiry by a superintendent of police is a condition precedent a fact which must exist before respondent number 2 can assume jurisdiction or authority for the purpose of passing the final order of dismissal against the petitioner. This is the main challenge which the petitioner is making before the Honorable High Court. Now, after mentioning all these facts, the grounds of appeal, the grounds of writ are to be mentioned separately. The first ground on the basis of which this writ of prohibition is sought from the High Court is that the order passed by the respondent number 2, that is IG Police UP, is illegal in as much as the same is not in accordance with law. Second ground is because the order passed by respondent number 2 is opposed to natural justice in as much as no opportunity of hearing was ever given to the petitioner. Petitioner is saying that the principle of audi alter partem was not followed. He was not heard at all, and the impugned order was passed against him without providing him any opportunity of hearing. Then the third ground, he says, because no preliminary inquiry was ever conducted in this matter as required by the rules. If you will see the rules framed under Police Act, you will find that the departmental inquiry procedure is that, first of all, a fact-finding preliminary inquiry should be conducted by the inquiry officer, and if the facts are prima facie found true, then matter should be referred to higher authorities for conducting final inquiry. So the petitioner is challenging that in this case, no preliminary inquiry was ever conducted by the inquiry officer, which was duly required by the rules. Then the fourth ground, which the petitioner has taken in this case, is that no copy of charge sheet was ever supplied to the petitioner. This is again unjust. In departmental inquiries, the delinquent officer has to be provided copy of the charge sheet along with all those documents on which the department is going to rely. But here the petitioner says that no copy of the charge sheet was ever supplied to him. This is the fourth ground in favor of writ of prohibition. Now, fifth ground is that none of the documents which are used against the petitioner were ever supplied to the petitioner. Dear students, according to rules, the copy of the charge sheet and copies of all those documents on which the department is going to rely are to be supplied to the delinquent officer. Now the petitioner says that neither the charge sheet nor the copies of the documents were supplied to him, and all those documents are being used against him, and he is not aware about the contents of those documents. And then he says no copies of the statements recorded against the petitioner were ever supplied to him. Yes, the rules require that whenever you conduct an inquiry, you are supposed to give copies of all the statements recorded by the inquiry officer to the petitioner so that he may prepare his defense. Then next ground of attack for this issue of writ of prohibition is that respondent number 2 is not legally authorized to conduct proceedings against the petitioner. He is not competent to inquire and to start disciplinary proceedings against the petitioner. And the next ground is, which the petitioner says, that respondent number 3, that is Inspector of Police Noida, was also not authorized to conduct inquiry against the petitioner. So, in the opinion of petitioner, the facts written by the petitioner are that Inspector of Police Noida was also not authorized to conduct inquiry against the petitioner. Now comes the trial. On all those facts mentioned above, all those grounds mentioned in the petition, the petitioner most respectfully prays that now he is claiming the writ of prohibition. A relief which the petitioner is asking from the court is that a writ, direction, or order in the nature of prohibition be issued to the respondents, prohibiting them from proceeding further with the disciplinary proceedings on the basis of the inquiry report of respondent number 3. The petitioner wants that these entire proceedings should be prohibited because they are against law. And then petitioner is also praying for any other order which this honorable court thinks fit in the circumstances of the case may also be passed in the interest of justice. Now, this petition is filed on 7th March 2020. So this date has to be mentioned at the end of the petitioner, at the end of the petition, and the petitioner will put his signature on the petition also, and the counsel for petitioner will also sign this petition. So petition is to be signed through counsel ABC advocate. He will also put his signatures at the end of the petition. So this is how the writ of prohibition is to be drafted. Now we will start the next writ, that is writ of certiorari. Dear students, we have already discussed that this writ of certiorari is an order issued by the High Court to an inferior court or body if he has acted illegally in order to adjudicate the same. And this writ of certiorari lies only to rectify the judicial decisions and to remove and adjudicate upon the validity of judicial acts only. The writ of certiorari can be issued to a judicial or quasi-judicial body on the following grounds. The first ground is want or excess of jurisdiction. Want means that the lower court had no jurisdiction, or excess of jurisdiction means that the lower court has exceeded the jurisdiction given to them by law. Second ground for issue of certiorari is violation of procedure or disregard of natural justice. And the third ground is error of law apparent on the face of record. Such an error which is noticeable, which is visible on the face of the record, is third ground for issue of writ of certiorari. We have also discussed earlier that this writ of certiorari is basically a supervisory jurisdiction of the High Court, and the court is not entitled to act as appellate court. It can be issued against subordinate courts by the High Court or Supreme Court. But the jurisdiction of certiorari is supervisory, not appellate. This has to be kept in mind when you start drafting the writ of certiorari. Here is an illustration of writ of certiorari before you. The leading case of Prince of Bombay versus Khushal Das. It was decided in this case that whenever any body of persons having legal authority to determine questions affecting rights of subjects and having duty to act judicially acts in excess of their legal authority, then a writ of certiorari lies, and the High Court or Supreme Court can quash the order of the lower court if the lower court has acted in excess of their legal authority. Then another illustration, Maneka Gandhi's case, a very important case. The passport of Mrs. Maneka Gandhi was impounded by the central government without giving her opportunity of hearing. And this order was quashed in a writ of certiorari because the principle of natural justice demands, the principle of audi alterum partem demands that you should hear the other side also. And if you have not heard Mrs. Maneka Gandhi and her passport was impounded without giving her any opportunity of hearing, so that order of the passport authority and the consequent order of the government was quashed while issuing a writ of certiorari in favor of Mrs. Maneka Gandhi. Now we'll start drafting the writ of certiorari. Again, you have to decide the court where you are going to file this petition. If your rights are violated in UP, then you will file your writ before the High Court of Judicature at Allahabad. If your rights are violated in Delhi, then you will file your writ before High Court of Delhi. So the first line, we have taken the example of UP. So the writ of certiorari is being filed in the High Court of Judicature at Allahabad. Again, in the bracket, we will mention original civil jurisdiction. Then writ petition number dash dash of 2019. You cannot write the writ petition because you are not aware of petition number, because the writ petition is yet to be filed. You are going to file a writ petition, so obviously you can't have the number of the writ petition in advance. Now, who is the petitioner? Petitioner is A, son of B, resident of flat number 906, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, is the petitioner. And who are the respondents? There are three respondents in this case. The first respondent is state of UP. Second respondent is drug controller of District Gautam Buddha Nagar, UP. And third respondent is Appellate Tribunal, Drug Controller, Lucknow, State of UP. These are the three respondents against whom the writ of certiorari is being filed. Now the center heading you will write down: a writ petition under Article 226 of the Constitution of India for the issue of a writ of certiorari. Now you will address to the court to the Honorable Chief Justice and his companion judges of the Honorable High Court of Judicature at Allahabad, UP. See, you are addressing your petition to Honorable the Chief Justice and all his companion judges of the High Court, because you are not aware as to who will hear your judge and where your petition shall be listed. You are not aware of the name of the judge. So you are addressing Honorable the Chief Justice as well as all his companion judges of the High Court at Allahabad. Now, the above named petitioner, that is A, son of B, most respectfully submits as under. Now, what are the facts? What are the facts to be mentioned in the petition for issue of a writ of certiorari? The first fact is that petitioner is a stockist and dealer in drugs and carries on his business in the name and style of Apollo Pharmacy at shop number 11 in sector 107 market, Noida, District Gautam Buddha Nagar, UP. Then the petitioner says that petitioner held a drug dealer's license number 4598 dated 1st January 2010 and has been carrying on his business for the last 9 years. He is doing his business since the last 9 years, since 1st January 2010, and he has a drug dealer's license also, and its number is 4598, which was issued on 1st January 2010. Now, what happened in this case? Petitioner says that on 1st January 2019, the petitioner received a notice from respondent number 2 to show cause why his license should not be cancelled for selling substandard and spurious drugs. He was also required by the notice to produce his license before respondent number 2. This notice was received by the petitioner that he should show cause why his license should not be cancelled, because he is selling substandard and spurious drugs, and he was also required by this notice to produce his license before respondent number 2. Now, on 7th January 2019, petitioner submitted his explanation to the show cause notice and submitted that he never sold any substandard or spurious drugs, and he sells only drugs in their original containers obtained from the reputed drug manufacturers. He expressed his inability to produce the license as the same had been submitted to the civil surgeon, Gautam Buddha Nagar, UP, for renewal. However, the petitioner attached a photocopy of the license along with his reply. Every year, legally, this license has to be renewed. So the petitioner has submitted his original license in the office of civil surgeon, District Gautam Buddha Nagar, but he filed a photocopy of the license along with his explanation, which was given to the respondent number 2 and 3. Now the petitioner says that without giving any proper consideration to the pleas and the grounds raised by the petitioner, the respondent number 2 passed an order on 15th March 2019 cancelling the petitioner's license. They cancelled the license of the petitioner, saying that the petitioner has failed to produce his license and the authorities did not rely on the photocopy of the license submitted by the petitioner. But dear students, you know, when the original document is not in your possession and the original you have submitted in the office of some government authority, so its photocopy should be relied upon, but the photocopy was not relied upon by the authorities in this case, and the license of the petitioner was cancelled on 15th March 2019. Now, the petitioner preferred an appeal against the order of respondent number 2 to respondent number 3. An appeal was filed, but by order dated 16th May 2019, respondent number 3 dismissed the appeal of the petitioner in a very mechanical manner, and again without giving any opportunity of hearing to the petitioner. Now the petitioner says that he has no other remedy but to approach this Honorable High Court for effective relief. And the orders passed by respondent number 2 and respondent number 3 are void and illegal for the following grounds, amongst others. After mentioning the facts, as you know, the grounds of writ are also to be mentioned in the writ petition. So you will draft the grounds also. Now the first ground which the petitioner prays and claims is that because of orders passed by respondent number 2 and 3 are illegal, void and vitiated, as they have acted in violation of the principles of natural justice, inasmuch as no opportunity of hearing was given to the petitioner. In this case also, the petitioner is claiming the maxim audi alter partem. At least you should hear the other party. Without giving any opportunity of hearing, the license of petitioner was cancelled. So he says that this is a violation of principles of natural justice. Second ground is that because both the respondent number 2 and 3 have placed great reliance on the report of Central Drug Laboratory dated 10th March 2019, which was never disclosed to the petitioner, and petitioner was not given any opportunity to meet and reply the said report. See, this license was cancelled on the basis of report of Central Drug Laboratory dated 10th March 2019, but its copy should have been supplied to the petitioner. Petitioner says this report was never disclosed to him. Its copy was never given to him, and no opportunity was given to him to meet and reply the said report. So this is another ground on the basis of which the writ is being claimed. Third ground is that because the authorities have been influenced by the failure of the petitioner to produce the license, but have themselves failed to consider the petitioner's explanation that the license was already submitted to the Office of Civil Surgeon for renewal. This is a palpable mistake committed by the respondents, that the petitioner was not at fault because he had submitted his original license in the Office of Civil Surgeon, District Gautam Buddha Nagar, for renewal, and he had attached a photocopy of the same, but the authorities have not relied upon the photocopy filed by the petitioner, and they have not considered this ground also, that since the original license has been submitted in the Office of Civil Surgeon, so they should have called that record from the Office of Civil Surgeon, or at least they should have relied upon the photocopy of the license. And the fourth ground, which the petitioner says, that respondent number 2 and 3 have not applied their mind to the facts and circumstances of the case, and they have failed to appreciate the value of the photocopy of the license when its original was submitted in the office of Civil Surgeon, District, Gautam Buddha Nagar. And the next ground is the petitioner says that the impugned order, which has cancelled the license of the petitioner, that order violates the fundamental right of the petitioner to carry on his trade and business as guaranteed by Article 19(1)(g) of Constitution of India. Once you have cancelled the license of the shopkeeper, obviously he is not in a position to carry on his trade and business. So this fundamental right under Article 19(1)(g) of the Constitution of India has been violated, says the petitioner. And this is the ground on the basis of which he has filed this writ petition, that his fundamental right given by the Constitution of India has been violated. Now comes the prayer. On these grounds, the petitioner most respectfully prays that a writ, direction, or order in the nature of certiorari be passed, quashing the order of respondent number 2 dated 15th March 2019, by which the license of the petitioner was cancelled, and the next order of respondent number 3 passed in appeal on 16th May 2019. The petitioner says that these two orders should be quashed, exercising the jurisdiction of the High Court relating to certiorari. And next relief is customary to write in all the writ petitions that any other order which this Honorable Court thinks fit in the circumstances of the case may also be passed in the interest of justice. So dear students, you have seen how a writ of certiorari is drafted, where the petitioner is claiming that the order passed by lower authorities should be quashed because the orders passed by the authorities are illegal, void, against the principles of natural justice. As usual, petitioner will sign this petition and date of petition will also be mentioned. So petitioner is filing this petition on 1st June 2019. And as I told you earlier also, the petition will be signed by the counsel for petitioner also. So you will mention through counsel ABC advocate, and he will also sign the petition. Now lastly, and the last writ which we will cover today is the writ of quo warranto. This is very important writ, and the object of this writ petition is to prevent a person who has wrongly usurped a public office from continuing in that office. This writ calls upon the person assuming the public office wrongfully to show cause to the court under what authority he holds the office. See, you may be appointed as Civil Judge Junior Division in the coming days, I am sure. Suppose at the time of appearing in the examination, your degree of LLB was not complete and you have been selected in the examination, and somebody files a writ against you, writ of quo warranto, then you are supposed to explain before the court as to how you are holding that office, whether you were legally qualified to hold the post of Civil Judge Junior Division or not. In recent history, there is a glaring example of a person of Assam Legal Services. He was appointed as law secretary, and then he was elevated as a High Court judge. He was neither an advocate nor a district judge. You know, for becoming a High Court judge, either you should be a district judge or additional district judge, or you should be an advocate of 10 years standing. But this person from Assam Legal Services, who was elevated to the High Court, he was neither an advocate nor a district judge. And a writ of quo warranto was filed against him, and he was removed from his office. So, quo warranto writ will ask you the question, will ask you what is your authority, how you are holding a particular public office. But this writ cannot be filed if you have usurped a private office. This writ lies only if you have usurped a public office, right? This is the name of another case, another leading example of writ of quo warranto, State of Assam versus Kusheshwar Saikia. The appointment of Mr. Saikia as additional district judge was challenged. As to how he was appointed additional district judge, as we have discussed that your appointment as civil judge junior division can be challenged in a writ of quo warranto. So the appointment of ADJ, additional district judge, was also challenged in this writ petition. You know, Article 233 of the Constitution says that appointment of district judges by the governor will be done in the state in consultation with the High Court. You know, higher judicial services, if you practice for 7 years as an advocate, you can become additional district judge directly, or by promotion from civil judge junior division to senior division, and then you may become additional district judge. Article 233 capital A deals with the validation of appointment of district judges, and Article 234 is the article for recruitment of persons other than district judges to the judicial services. Those appointments shall be made by governor after consultation with State Public Service Commission and High Court of that state. If you are to be appointed as civil judge junior division, then UP Public Service Commission will take your examination, and then governor, after consultation with the High Court at Allahabad, will appoint you as civil judge junior division. Likewise, why High Court has say in the appointment of the civil judge junior division, it is because of Article 235. Every High Court shall have control over all the subordinate courts under his state. And 236 district judges defined, and judicial services are also defined. With this much introduction, dear students, we will now see how to draft a writ of quo warranto. Show cause notice. Show cause as to how you are holding a particular public office. So the opening line is, you are going to file your writ in the High Court of Judicature at Allahabad. So you are supposed to write down before the Honorable High Court of Judicature at Allahabad. In the bracket, you will write down original civil jurisdiction. Again, writ petition number -- of 2019. Name of the petitioner is A, son of B, resident of flat number 52, Alambagh, Lucknow. He is the petitioner. And the respondents are AB, son of CD, again resident of 54 Alambagh, Lucknow. XY, son of YZ, resident of 58 Alambagh, Lucknow, presently Chief Minister of UP. And third respondent is the Governor of UP. Again, the heading, petition under Article 226 of the Constitution of India for the issue of writ of quo warranto. To whom you are addressing your petition? To the Honorable the Chief Justice and his companion judges of the Honorable High Court. The above named petitioner most respectfully submits as under. What is the submission of petitioner? Number 1, that the petitioner is a taxpayer and a voter of Lucknow City Central Constituency for UP Legislative Assembly. Petitioner says that I am a taxpayer and I am a voter. I have a right to vote in the election of MLAs in UP Assembly. And next he says that respondent number 1 is an illiterate person who contested the general elections held in November 2018 for the membership of UP Legislative Assembly from Lucknow City Central Constituency, but he lost the election. Respondent number 1 is the losing MLA who could not be elected. Third, he says that respondent number 1 was appointed as law minister in the government of UP by respondent number 3, that is the governor of UP, on the recommendation of respondent number 2, that is Chief Minister, on 6 January 2019, as published in UP Gazette of 6 January 2019. Now respondent number 1 took the oath of office of law minister on the same day. See, the person has lost the election of MLA, but still constitutionally, he can be appointed as a minister. There is no doubt in it. But within 6 months of taking oath, he has to become a member of either house of the state assembly or the legislative council. He has to become a member of either house within 6 months. Now, the next fact is that respondent number 1 was not a member of either houses of legislature of state of UP at the time of his appointment as law minister. This is admitted fact that the person who is appointed law minister, he lost the elections of MLA. He was not member of either house, but still constitutionally he was appointed as law minister. Now the petitioner says that respondent number 1 was nominated as a member of UP Legislative Council on 6 January 2019 by Governor of UP under Article 177 Clause 5 of Constitution of India on the advice of Chief Minister. Yes, Article 171 permits that few persons can be nominated by the Governor in the Legislative Council on the recommendation of the Governor. So the Governor, in accepting the advice of the Chief Minister, first of all, appointed respondent number 1 as law minister, and then he was nominated as member of the UP Legislative Council. Now the petitioner says that respondent number 1 is still an illiterate person and he does not possess any special knowledge or practical experience in the field of law, literature, art, cooperative movements, or any other social service. You see, these are the grounds under Article 171 that the person who is appointed or nominated as member of UP Legislative Assembly, he should have a special knowledge or practical experience in the field of law, literature, art, cooperative movements, or any other social service. The case of petitioner is that respondent number 1 is an influential member and leader of his community in the state of UP, and a large number of voters, being more than 40% in the constituency of the chief minister, those votes belong to respondent number 1 because he is the leader of that community. So the chief minister thought that if I will nominate respondent number 1 as law minister, in the next election he will get the benefit of his community. All his community members will vote in his favor. So the next contention of the petitioner is that respondent number 2, that is chief minister, got the respondent number 1 nominated to the Legislative Council of UP in spite of his defeat at the said general election of MLAs, with a view to utilize his influence and influence of his community for securing votes in the next general election. The main purpose, petitioner says, the main purpose of a nomination and making him law minister was that the chief minister himself has to contest the next election also. Yes, the ground mentioned by the petitioner is that respondent number one is an influential member of a particular community in the state of UP, and large number of voters, being more than 40% in the constituency of respondent number two, that is the chief minister, they belong to community of respondent number one, and respondent number two, that is chief minister, got the respondent number one nominated to the Legislative Council of UP in spite of the defeat of respondent number one in the said general election of MLAs, with a view to utilize his influence and influence of his community for securing votes in the next general election. This is the main ground mentioned by the petitioner. Now, in criminal appeal number 213 of 2018, in the case of state of UP versus AB son of CD, this honorable court was pleased to make an adverse remark against respondent number one regarding his bad character. And this appeal was filed by state of UP challenging the acquittal of respondent number one, who was appointed as law minister in a case under section 376 and 302 IPC relating to PS Alambagh, Lucknow. This petitioner is telling that the character of respondent number one, who is appointed as a law minister, is not clean, and his character was written by the High Court in an appeal. So he is filing the copy of criminal appeal number 213 of 2018 along with this petition. Now the petitioner says that the nomination of respondent number one to the UP Legislative Council by respondent number three and his appointment as law minister in the UP government are quite illegal, and he has no right to become a member of UP legislature and hold the said office of law minister. This is the main ground. He says that petitioner, being a voter and a conscious citizen of India, is interested in not allowing the Constitution of India to be subverted in the personal interest or in the party interest by anybody, and begs to prefer this writ petition inter alia on the following grounds. Now the petitioner will mention the grounds of quo warranto writ petition. The first ground is that respondent number one is an illiterate person. He does not know how to sign his own name. He puts his thumb impression on all the documents instead of his signature. This is the first ground. He is not an expert member. He is not expert in law, literature, science at all. He is an illiterate person. Second, because respondent number one does not possess any special qualification as required under Article 171 Clause 5. Thus, his nomination to UP Legislative Assembly is ultra vires of the Constitution of India. This is what petitioner says, that in order to use the influence of his community and voters, the chief minister got nominated him in the Legislative Council and appointed him as a law minister. Whereas the criteria of Article 171 Clause 5 was not fulfilled because he is an illiterate person. An illiterate person has been appointed as a law minister in the UP. Third ground, he says that because the nomination by the governor of UP, exercising the powers under Article 171 Clause 5, has been designed to introduce only those persons in the legislature who do not seek election but have special knowledge or practical experience in the field of literature, science, art, cooperative movement, or any other social service. But such nominations are done in public interest. But our respondent number one does not possess any such qualification, and his nomination is totally against the Constitution of India and is as such void ab initio. Petitioner says that nomination of the respondent number one is absolutely illegal just to give support to the post of law minister. Why? Because the chief minister wants to use his votes use his votes of his community in the coming election. Next ground, which the petitioner says that because the use of a constitutional provision to introduce a defeated candidate in the legislature by backdoor with ulterior purpose of catching votes in future elections, for the purpose of inducting respondent number 1 or continuing him in the ministry, is a fraud on the Constitution of India. Petitioner says that a fraud on Constitution has been committed by such a nomination and such an appointment of a defeated candidate as law minister. Then petitioner says ground E, because the appointment of respondent number 1 as law minister and his nomination to the UP Legislative Council are mala fide and bad in law. His appointment is mala fide and bad. Now what is the prayer? The prayer is, the petitioner most respectfully prays that this honorable court may be pleased to issue a writ, order or direction in the nature of quo warranto against respondent number 1, requiring him to show authority under which he holds the office of member of UP Legislative Council and the office of law minister of UP government. Now respondent number 1 under writ of quo warranto has to show whether he is qualified to hold the nomination in Legislative Council and whether he is consequently qualified to be appointed as law minister in the UP government. And the petitioner says that the honorable court may issue any other writ, order or direction as is deemed fit and proper in the circumstances of the case, and his petition should be allowed. So this is how, dear students, the writ of quo warranto is being drafted. You will mention the place, you will mention the date. Petitioner will sign this petition along with counsel. ABC advocate will also sign this petition. So with this, we have concluded the drafting of all the 5 kinds of writ petitions. So thank you very much, dear students.